Did you form an opinion to a reasonable degree of professional certainty, to medical certainty, as the cause of death of Cora?
Yes.
And what was that?
Asphyxia.
Meanwhile, bombshell moments from Lindsay's former prescriber when things get tense on cross-exam.
I know it doesn't say not, but that is exactly what I meant.
When did you see this that you noticed that it did not say not?
I don't care what it says. I know what I meant.
Plus, could a viral TikToker be called as a witness?
I'm a Massachusetts social worker, and I also worked on the exact inpatient unit at McLean for nearly 8 years that Lindsay Clancy was a patient at.
This woman posted a video on TikTok, which, much like yourself, I'm sure, I hardly know what TikTok is.
And one thing no one could have predicted, this comment from the defense.
Cannabis, the weed, the devil's lettuce. How about that?
Here's a complete recap of the jaw-dropping moments in this week's coverage of the Lindsay Clancy trial. This is of the Lindsay Clancy trial is now in the books, and it's definitely made its mark. From courtroom outbursts to spicy moments on cross-exam, there's a lot to unpack, and we'll do it all, taking you through the most jaw-dropping courtroom moments that happened this week before sitting down with our expert guest, TikToker Elena True Crime, who's been following this case since day one. She's been giving her insight to her more than 70,000 TikTok followers daily about all the bombshells we've seen so far.
There were some really big moments, in my opinion, including, but not limited to, the fact that the very first time that Lindsay's psychiatrist, who prescribed her all of these medications, saw her in person was on Friday in court. That is right. All of their appointments, 14 appointments, were done in telehealth.
Elena is right. That's something everyone is talking about. The fact that Dr. Jennifer Tufts, Lindsay Clancy's former psychiatrist, never once saw her in real life until the trial began.
14 appointments?
Yes.
Every single one of them were by telemedicine, weren't they?
Yes.
First, a psychiatrist who prescribed medication for a severe mental health condition while practicing for only 1 month. Second, every single appointment between doctor and patient happened on a screen, never face to face, even as symptoms deteriorated. Third, a medication with an FDA black box warning for suicidal ideation was given to a postpartum woman who then told that same doctor she was close to ending her life. And fourth, when that woman was finally hospitalized, the very people now testifying against her are the same ones listed as defendants in her medical malpractice lawsuit. This is week 3 of the Lindsay Clancy trial, and what unfolded in that courtroom this week raises a question the court record doesn't fully answer. One that separates what actually happened from what people believe happened.
Off of this, but when Lindsay called the crisis hotline, that Letitia Dukes, one of the testimonies from yesterday that they gave her in case she started feeling suicidal, and she called it, and they turned her away because she did not have a, quote, plan. So they could not help her, and then they didn't give her any other resources to go to. I mean, what are we doing here?
Oh my God, that little part, truly, I was just shocked by it. But like, full disclosure here, in the past when I've gone to the doctor, I will never forget this. I said to the doctor, like, I'm struggling. And she's like, are you suicidal? And I was like, yes. And she said, okay, there is a 5 to 7 month waiting list. And I was like,
what?
Okay. And so to hear that, in this case, I mean, I'm just saying this to say there clearly is a problem going on in the mental health system. Like, there truly is. And that is so stark and just chilling. So if any of the jurors, because a lot of us experience mental health issues, or our friends, our family, whoever, if they do, I mean, I feel like that's got to pull.
On January 24, 2023, in Duxbury, Massachusetts, Lindsay Clancy strangled her 3 children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Ken. She attempted to end her own life by cutting her wrists and throat, taking pills, and jumping from a 2nd-story window. She survived but has been paralyzed from the waist down. The defense admits she killed them. That's not disputed. What is disputed, what the entire trial hinges on, is whether she was mentally sound when she did it. The insanity defense in Massachusetts requires one question only at the moment the crime occurred: was the defendant of sound mind? The defense says no. They say Lindsay Clancy was in the grip of postpartum psychosis, untreated, undiagnosed, made worse by medical failures. And they want the jury to understand how she got there. The person at the center of this question, the one the jury heard from this week, was Dr. Jennifer Tufts. Tufts was Lindsay's psychiatrist. She prescribed most of the medications. She saw her 14 times, and according to testimony that emerged during cross-examination on Monday morning, she never saw her in person. Not once. Not in person. 14 appointments. 14 virtual visits. All of them. That detail alone, that single fact, stopped the courtroom. It's the kind of fact that makes you pause because it contradicts something most people assume about psychiatric care, something about the basic work of knowing a patient.
Elena is right. That's something everyone is talking about. The fact that Dr. Jennifer Tufts, Lindsay Clancy's former psychiatrist, never once saw her in real life until the trial began.
14 appointments?
Yes.
Every single one of them were by telemedicine, weren't they?
Yes.
Until you came in this courtroom Friday, you never saw this woman in person, did you?
Correct.
And did you give her a hug? Oh no, you're on telemedicine, so you couldn't give her a hug, could you?
On top of that, Dr. Tufts was a relatively new doctor at the time she first saw Lindsay, having only officially practiced in that space for about a month before Lindsay became her patient. She's also a name you might recognize, as she's listed as a defendant in the civil lawsuit alleging medical malpractice.
Here's what the documented record shows. Dr. Tufts received her board certification in psychiatry in August 2022. She then began practicing independently with her full credentials for the first time in her career. About 1 month later, in mid-September 2022, Lindsay Clancy came to her as a patient. Lindsay had anxiety. She had depression. She was postpartum. She had a lot going on. Tufts had been in independent practice for approximately 1 month. And when asked during cross-examination how many patients she had treated for postpartum psychosis in that month, Tufts said none, because it is a very rare disorder. She acknowledged it exists. She acknowledged that people with postpartum psychosis often hear voices that it is a legitimate diagnosis. But she had never treated it. Yet she was now treating Lindsay Clancy, a postpartum woman with escalating symptoms, all while practicing for roughly 4 weeks total in his field.
Dr. Tufts was called to the stand last Friday by the Commonwealth, but this week her testimony began with cross-examination, questions from the defense. She testified she received her board certification in August 2022. She then saw Lindsay Clancy for the first time just weeks later on September 15th, 2022.
So you were practicing as a psychiatrist for a little more than a month.
I was practicing independently with my full credentials for about a month, but the training is just immense that goes on before that.
Now, in August of 22, up until when you saw Lindsay, how many patients in that month or so had you treated for postpartum psychosis?
How many patients in a month? Up until that
Yeah,
month?
I'm asking you about when you started working in August of 22 for Astor, and you are now on your own as an employee. How many patients had you treated before you saw Lindsay Clancy for postpartum psychosis?
This fact alone doesn't prove negligence, a word Tufts used repeatedly when asked if she believed she had fallen short. That's important to flag. The defense alleges negligence. Tufts denies it. What is documented is that she was relatively new to independent practice, that she had no prior patient experience with the condition Lindsay would later be diagnosed as suffering from, and that every meeting between them happened on a screen. The question of whether that constitutes negligence is for the jury. But the question of whether it happened, whether all 14 appointments were by telehealth, is settled. Tufts confirmed it. The jury heard it. The defense attorney, Kevin Readington, asked her directly, until you came to this courtroom Friday, you never saw this woman in person, did you? Her answer was one word. Correct?
Telemedicine.
Telemedicine. Is it fair to say that after, 14, you said to the jury, 14 appointments that you had with Lindsay during that period from September till January? 14 appointments?
Yes.
Every single one of them were by telemedicine, weren't they?
Yes.
until you came in this courtroom Friday, you never saw this woman in person, did you?
Correct.
Were you ever concerned about her mental health as a person?
Absolutely.
She was crying. She told
What emerges from the cross-examination is a pattern. The defense attorney walked through her medical notes, the things she documented after each appointment. And he found gaps, things she documented and things she did not. For example, Tufts testified that after Lindsay took Zoloft, a medication Tufts herself prescribed, Lindsay reported severe trouble sleeping. Readington asked if Tufts had documented that side effect in her notes. She said no, she did not write it down. He pressed her. You're telling the jury you don't recall what side effects she told you about, but you do remember they were common ones that are temporary. Is that what you said? Yes, she answered. Because if they were anything else, I would have documented it. That logic, that reasoning, raised an eyebrow in the courtroom. If the side effects were severe, she would have written them down. But she didn't write them down, so they must have been common. It's a kind of backward reasoning that depends on trusting the absence of documentation as evidence itself. And Readington didn't let it stand. One specific exchange became the flashpoint. Tufts wrote in her notes, and the jury could see it on a screen in the courtroom, no sleep last night, falls asleep after 40 minutes, heart racing, severe anxiety, worrying about kids, baby, sleep, yawns but not drowsy, not hyper-pressured speech. That last phrase is what matters, not hyper-pressured speech. Readington read it aloud to Tufts. She wrote in the medical record, not hyper-pressured speech, which would mean the patient did not have pressured speech, a symptom of psychosis. So Readington asked her, when you wrote that, you did not say not pressured speech, you said pressured speech, correct? Tufts denied it. The word not is right before not hyper, comma. Pressured speech, she said, reading from what was now displayed for everyone to see. And then something happened that the trial watchers noted. Readington asked her directly, am I reading this correctly? The jury will be able to look at it. You put not hyper-pressured speech. Did I read that right? Tufts said yes, but your interpretation is incorrect. This moment matters not because it proves Tufts was careless, though that's what the defense was arguing. It matters because it illustrated a broader theme of the cross-examination. The question wasn't whether Tufts understood what she wrote. It was whether the medical record she created actually captured what was happening with the patient. And if the record doesn't match the reality, then what is the record worth as a foundation for treatment decisions? That's a question the jury will have to decide. But the tension is real. A doctor says, I know what I meant, but the document says something else.
No sleep last night, falls asleep after 40 minutes, heart racing, severe anxiety, worrying about kids, baby, sleep, yawns but not drowsy, not hyper-pressured speech.
what was that? Not hyper what?
Not hyper, not pressured speech is what I meant. I know it doesn't say not, but that is exactly what I meant.
When did you see this that you noticed that it did not say not?
I don't care what it says. I know what I meant.
A doctor says if it were serious, I would have written it down, but maybe she didn't write it down because the system limited her options. Tufts testified that the electronic health record she used had dropped down menace checkboxes, preset options. There were certain parts where she could write freely. But when describing patient status, she was constrained to click one of 3 choices. You're like a robot, Readington said. You can't take a pen and write something down. You have to do the drop box and the X on the computer. You're a doctor, why are you limited? Because of the technology, she answered. Now, this is a moment to step back and note something. The actual competence of Dr. Tufts, the actual quality of her clinical judgment, is being litigated. Some of what the jury heard this week was evidence that points one direction. Some of it points another. For example, Tufts prescribed Zoloft. Zoloft carries an FDA black box warning, a warning that says, in substance, that this drug may cause suicidal or homicidal ideation, especially in young people.
It was Dr. Tufts who prescribed Lindsay the medication Zoloft in fall of 2022.
Suicidal ideation and homicidal ideation. There's a black box warning on Zoloft, along with other SSRIs, right?
Under
Yes
age,
or no?
for children and adults younger than Lindsay.
Excuse me, doctor, I apologize. Can you just listen to my question and answer it yes or Is there a black box warning on Zoloft?
Yes,
Okay. And a black box warning is required or prescribed by what, the FDA?
probably.
Probably. And it basically warns that, especially with young people or young adults, that it may cause suicidal or, God forbid, homicidal ideation. Yes?
Readington asked her directly, "Is there a black box warning on Zoloft?" "Yes," she said, "and it warns that especially with young people or young adults, that it may cause suicidal or homicidal ideation." "Yes. And why would you prescribe Zoloft to a young woman who's postpartum, who's coming to you with anxiety, who's telling you she can't sleep, she's got all of these symptoms, and you prescribe a medication that would have a side effect of trouble sleeping?" Tufts' answer was that individuals have very varied responses to medications. Some have no side effects, some have one or two. It's impossible to predict, but Zoloft is a top choice, a first-line medication, and there's extensive research supporting its use. That's what the general consensus among psychiatrists says. That's documentation. That's on the record.
And why would you prescribe Zoloft to a young woman who's postpartum, who's coming to you with anxiety, who's telling you she can't sleep, she's got all of these symptoms, and you prescribe a medication that would have a side effect of trouble sleeping?
So individuals have very varied responses to medications. Some have no side effects, some have one or two. It's impossible to predict, but Zoloft is a top choice, a first-line medication for
Says
her.
who?
It was
Says who?
says it's the general consensus
Right, know
among
about the lawsuits
psychiatrists.
against
Hold on,
Zoloft,
again,
right?
again, you can't have both of you talking at the same time. So let her finish her answer, and then I'll give you plenty of time to follow up any questions regarding her answer. So, you finish your answer on that?
There's extensive research supporting the use of sertraline in this instance, and the general consensus.
She didn't make it up on the spot. That's a defensible clinical position, so the jury heard the case for concern about the black box warning and the sleep issues, and they heard the case for defense about first-line treatment and clinical consensus. What they haven't heard is the full weight of what happened after that. Because the treatment didn't work, not in the way anyone hoped. Lindsay's next provider was a nurse practitioner named Julie Paul, recommended to her by her mother-in-law. Paul testified this week as well.
Recommended to by her mother-in-law, Susan Clancy.
Yes, I asked her specifically if she felt like she wanted to harm herself or her children, and she said no.
And how about asking her about homicidal ideations?
Yes,
And did she indicate whether she had any?
she did not.
Did you also ask her whether she had experienced any auditory hallucinations?
I did.
And did she experience any?
Not at the time, no.
And did she indicate to you whether she'd ever experienced any?
No,
How about visual hallucinations? Did you ask her about those?
I did.
And did she indicate that she had experienced any?
No,
And delusions, did you ask her whether she had any delusions?
I didn't ask specifically about delusions, I believe.
Paul stated that Lindsay tested very high for anxiety, but not suicide.
She said she asked Lindsay directly if she felt like she wanted to harm herself or her children. Lindsay said no. She asked about homicidal ideation. Lindsay said no. She asked about auditory hallucinations. Lindsay said no. She asked about visual hallucinations. No, she asked about delusions. Paul said she didn't ask about delusions specifically, but she noted that Lindsay tested very high for anxiety, but not for suicidal ideation. That was Paul's assessment. No suicidal ideation. Then Paul moved out of state in late November 2022. Lindsay was referred to another nurse practitioner, Rebecca Gelada, and here the record shifts again.
Gelada testified Patrick Clancy was allegedly dismissive when she discussed a possible diagnosis of bipolar disorder.
Did you express to Ms. Clancy thoughts that you had about her diagnosis based on your interactions over the last few weeks?
I did.
And what was that?
I discussed with her and her husband the possibility of potentially an underlying bipolar disorder. I based this on several factors, one of them being that she had such what we call an activating response to the Zoloft. It's unusual for somebody to describe taking Zoloft and then going 48 hours without sleep and not being tired. So that raised my clinical suspicion a bit. And she had been, I would say, having difficulty tolerating other antidepressant medications that we had been trying to have her take since then. And so again, I'm wondering if it's because potentially there might be an underlying, what we call mood disorder, bipolar disorder.
And as far as the information that you had about her past psychiatric history, were there any indicators to you about manic episodes?
No.
And so while you noted that there were some concerns reported, did what was reported to you rise to the level of diagnostic criteria for bipolar disorder?
Gelada testified that she discussed with Lindsay and her husband the possibility of an underlying bipolar disorder. Why? Because Lindsay had what Gelada called an activating response to the Zoloft, meaning she took the drug and went 48 hours without sleeping but wasn't tired. Gelada said that's unusual. It raised clinical suspicion. But when asked whether what she observed actually rose to the level of diagnostic criteria for bipolar disorder, Gelada said not at that time. There weren't enough indicators in the documented history. Patrick Clancy, when Gelada mentioned the possibility of bipolar disorder, said, "My wife is not bipolar." Lindsay, according to Gelada's testimony, said nothing. And then, on December 1st, Lindsay called Dr. Tufts and said she was close to having suicidal ideation, feeling hopeless. Tufts' response, according to her testimony, was to tell Lindsay that there was hope, that there were treatments, including partial hospitalization programs, and that she still had options and a reason to hope. But Tufts did not recommend that Lindsay come in person to see her. She did not recommend hospitalization. She recommended continuing the telehealth arrangement.
When Lindsay expressed suicidal ideations, Dr. Tufts testified she still didn't recommend seeing Lindsay in person.
And on December 1st is when she told you, again, that she was close to having suicidal ideation, feeling hopeless. Do you recall that?
Yes.
Now, on the interval history, on that date, you indicated that she can't sleep, she's panicking, she had worse depression, intrusive thoughts, she was numb, nothing mattered, I feel like I'm going to die, denies suicidal ideation, but, quote, yesterday, close to it, feeling hopeless. Did you give her therapy and validations after she told you that?
I believe that I did.
What did you do? You got a woman that's telling you that she's hopeless. She doesn't care if she dies. She can't sleep. What did you do to validate on your therapy?
Well, I told her that this was something that we could address, that there was hope, that there were treatments, and there are different types of treatment programs that are more supportive, like partial hospitalization programs. So she knew that she still had options and a reason to hope.
Did you ever suggest to her that maybe you ought to come in and see me rather than talk on the computer?
Talking with her over the video did not seem like an issue. It didn't seem like there was anything that I was missing or that there was any need to see her in person.
The defense highlighted that fact when you explained to her your thoughts about her reactions to medications and these reported symptoms. Did you ever suggest to her maybe she ought to come in to see me rather than talk on the computer? Tufts said talking with her over video did not seem like an issue. There was nothing she was missing. There was no need to see her in person. That's the tension at the core of this week's testimony. A doctor who never saw her patient in person, who had been practicing independently for roughly 4 months, who had no prior experience with the condition the defense alleges the patient had, continued to treat her remotely even as the patient reported thoughts of suicide. Now, there's a detail here that needs attention, and it's a detail that the source material itself contains, but that most of the viral commentary online hasn't centered. Lindsay was also being seen by other providers. She wasn't only seeing Dr. Tufts, she was seeing multiple clinicians. This is called polypharmacy, and when it involves multiple prescribers, it's called fragmented care. The civil lawsuit Lindsay filed, a 7A4-page document, explicitly alleges that her clinical course was significantly complicated by polypharmacy and the involvement of multiple prescribers, which in effect obscured an accurate diagnosis and appropriate intervention.
The civil lawsuit plays a lot into the plea by the defense, so let's talk about that briefly. Lindsay Clancy has been charged with 3 counts of first-degree murder in the deaths of her children: 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan Clancy. Now, this happened back on January 24th, 2023 in the family's Duxbury, Massachusetts home. When Lindsay's then-husband Patrick went out to run a few errands, Lindsay reportedly strangled each one of her children with exercise bands before attempting to end her own life by slitting her wrists and throat, taking some pills, and jumping out of a second-story window. She survived the jump, but has been paralyzed from the waist down. According to testimony, Patrick arrived home to find Lindsay outside. He called 911 and later found the children. Since that horrific day, Lindsay's team has admitted she killed the kids, but they say she's not criminally responsible, and this is really important. It's essentially the insanity plea in the Commonwealth of Massachusetts. Lindsay's defense says she killed the children, yes, but she can't be found guilty of murder, for at the time of their deaths, she was not of sound mind. Specifically, she was suffering from postpartum psychosis. The defense points to what they call a cocktail of medications Lindsay was prescribed, 13 in all, leading up to her children's deaths. This is also referenced in that civil lawsuit Lindsay filed alleging medical malpractice. The suit reads in part, Lindsay's clinical course was significantly complicated by polypharmacy and the involvement of multiple prescribers, which in effect obscured an accurate diagnosis and appropriate intervention and treatment, even though Lindsay did all she could to obtain the appropriate treatment. That's
not something Tufts alone caused. That's a systemic problem. Multiple doctors, no clear coordination, medication upon medication, 13 in total by the time of the incident. That's a detail worth sitting with. It doesn't mean Tufts is blameless. It means the failure, if there was a failure, was distributed. And that makes the question more complicated, not simpler. Was it one doctor's negligence, or was it the way the system broke down across many points of contact? The jury will decide about Tufts. But the broader pattern the defense is trying to establish is about the system itself. Here's where the mid-trial pivot becomes important. Much of the online commentary, especially on TikTok, has painted this as a story of one bad doctor. Dr. Tufts, the young, inexperienced psychiatrist, missed the signs, failed to see the patient in person, prescribed the wrong drug. That narrative is clean, it's focused, and it's incomplete. Because late this week, the trial turned to another piece of the story. What happened when Lindsay was actually hospitalized? On New Year's Eve, 2022, Lindsay went to the emergency room. She was transferred to Micklin Hospital, a major psychiatric facility in Massachusetts, on January 1st. She stayed there for roughly 3 weeks, until shortly before she killed her children. And now the defense is preparing to call a witness to that hospitalization, a TikToker named Emily Thorndike, who worked at McLean for 8 years as a clinical social worker.
Your Honor, basically, as the motion speaks for itself, there is a woman, her name is Emily Thorndike, who's a LACSW here in Massachusetts. She owns and is an independent operator of her own clinical social work establishment called Wise Mind Therapy.
That's this woman who made a TikTok a few weeks back. She used to work at McLean, the medical facility Lindsay Clancy stayed at in late 2022 and early 2023.
When a patient is admitted to the unit, they are specifically assigned two clinicians. One is a psychiatrist, and the second is the social worker. You are literally told as a patient, this is your treatment team. This is your doctor. This is your social worker. With that being said, legally, every patient needs to be seen at least once a day by a doctor. So on the weekends and on the holidays, when the physicians in charge, the regular physicians who are working there, are off because they work weekday hours, on the weekends and on holidays, the patients still need to be seen by a doctor. How that works is that there is one doctor who comes on the weekend and holidays, and he or she sees every single patient on the unit, okay? And if you think about it, there's a reason that the doctors who are there during the week are only assigned 4 to 5 patients, because you cannot spend a long amount of time as a doctor with 23 different patients.
Last week, the defense made it known they want to call Emily as a witness. Their motion reads in part, Ms. Thorndike literally worked the unit that Lindsay Clancy was presented to on New Year's 2022-2023. Ms. Thorndike would testify based solely upon her firsthand observations and 8 years of experience while employed at McLean Hospital's short-term unit between 2014 and 2021.
She left, as the court is aware from the motion. I vetted her out. I obviously would be concerned if there's any so-called axe to grind, if you will, any lawsuits pending. Were you fired? Did you have any difficulties? Any claims for harassment, hostile workplace? Absolutely nothing. She has friends that are still employees that still work at McLean. And I do not know this woman. I have literally never met her. Her involvement in this case came about after one of the prosecutors, I don't recall which, made it out on direct examination that McLean is some kind of a 5-star institution where the doctors, the psychiatrists, the psychotherapists, the counselors were all banging into each other in the hallway trying to interview Ms. Clancy, who was just blithely refusing care and treatment, which is not the case.
The Commonwealth had some reservations about this potential witness.
Aside from that, we have a number of other issues with this witness. One is this isn't somebody that's proposed to be an expert, so they're not relieved, they wouldn't be relieved of a sequestration order. But this woman's TikTok, admittedly, she's been following the trial. She goes on for several minutes in a very long TikTok video where she identifies what she thinks are lies based on her observations of Patrick Clancy's testimony. We have no idea what her thoughts are or what her comments are on the rest of the trial that we assume she's watched based on her comments in this particular video. That she outlines in this video her experiences at McLean and her observations and how they are different from what was portrayed in that particular witness's testimony.
Her username is Emily Tita Therapy. She has posted videos on TikTok criticizing the prosecution's portrayal of care at McLean, saying the Commonwealth is misrepresenting what it's actually like to be a patient there. She claims that the prosecution made it sound like a 5-star institution where doctors and therapists were lined up to help Lindsay, when in fact she was there during New Year's, a time when many staff members are off, and she was being seen by rotating providers, not a consistent treatment team. That's a claim that hasn't been tested yet. The judge said he would take the motion under advisement. It's possible the TikToker will testify. It's also possible she won't. This is a moment to name what's happening. The case has now intersected with social media in a very specific way. A true crime trial is being narrated in real time on a platform designed for short-form video, where nuance is a liability and certainty is currency. The vast majority of people following this case online never read the 784-page civil lawsuit. They don't know the names of all 13 medications. They don't understand polypharmacy. They understand one visual a video call instead of an in-person visit, a young doctor, a sick mother, a failure to care. And that story is real, it's in the record. But it's not the only story in the record. The trial is now at a point where the defense begins its case next. That's when they'll call their own experts, their own witnesses. The narrative may shift, or it may harden further in the direction it's already going. What's certain is that the facts on the record, the documented testimony, is more complicated than any tweet or TikTok can hold. Here's a genuine open question for you, and I'm asking because the record itself doesn't fully resolve it. If postpartum psychosis is as rare as Dr. Tufts said it is, as rare as the one in 2000 statistics suggest, would most psychiatrists have caught it?
I mean, there has been discussion of postpartum depression before all of this. I mean, I definitely have heard about it. I know women who have experienced it. It was kind of out there in the world. But now, I mean, I can't go on Instagram, TikTok, Facebook, any social media without someone coming forward and saying, I experienced postpartum depression. A lot of people experience postpartum psychosis more than I thought. I mean, the statistics are 1 in 2,000. But if I'm just looking online, going through, my timeline, I'm seeing all of these women who say, yeah, I did experience something like this. This did happen to me. So from your perspective, if there are mothers on the jury, do you think that helps or hurts?
Would an experienced psychiatrist have diagnosed it before Lindsay killed her children? The Commonwealth's case so far suggests yes. The defense's case, when it comes, will likely suggest no, that the condition is missed regularly, that it's hard to diagnose, that the system isn't set up to catch it. And if that's true, does that mean individual doctors are responsible, or does it mean something deeper about how we screen for, recognize, and treat maternal mental health crises? I'm genuinely asking. What do you think the answer is? Share in the comments what you think about that question. Because here's what hasn't been lost in the noise of this trial. Lindsay Clancy's 3 children are dead. They were real. Cora was 5 years old. She liked to read. Dawson was 3. Ken was 8 months old during this week's testimony. When the medical examiner described the autopsy findings, the trauma to Cora's neck, the pattern of injury consistent with strangulation, Lindsay broke down in the courtroom. She cried. She said, I can't do it. The judge called a recess. When the court reconvened, her head was on her desk and she was still crying. The jury saw that. They heard the autopsy details. Some of the jurors cried too.
Lindsay broke down 3 separate times on Wednesday, including when a forensic pathologist discussed Cora and Dawson's autopsy findings.
And did you perform an autopsy on Cora Clancy on January 25th, 2023?
Yes.
And did you follow that same process with Cora Clancy?
Yes. And then I noted evidence of trauma of the neck with associated injuries of her head and minor injuries of her right arm and of her legs as well.
And in terms of the injuries that you observed, evidence of trauma to her neck, were there also injuries to her face and neck area that seemed to go along with the trauma to her neck?
Yes, there were findings of the head that were associated with the trauma of the neck.
And what were those?
So on her neck, she had a ligature furrow.
As the testimony continues, you can literally hear Lindsay breaking down.
So again, the furrow is a ligature is when you have external compression by an object on the neck, and a furrow is simply a pattern of injury that occurs beneath it. It can be an imprint, it could be a pattern, or it could be more developed types of injuries such as bruising or abrasions.
And what about injuries?
You can actually hear Lindsay crying, saying, I can't do it.
What about injuries?
The judge even notices this and calls for a break.
All right, counsel, we're going to take a break this time, all right?
All right. George, close your notebook. Place them on the chairs, please. This way, please.
Recess for a few minutes. I'm going to come back. We'll speak to counsel in regards to schedule. Okay.
The defense argues that this emotional response, this ability to feel devastated by what she did now, supports the idea that she was not herself when it happened, that she was in a state of altered mind. The prosecution will argue something else. The question isn't settled by emotion, it's settled by law, and law requires facts testimony, evidence. What we know factually is this: Dr. Tufts never saw her patient in person. She had been practicing for roughly a month when she took on the case. She prescribed a drug with a black box warning for suicidal ideation to a woman who reported suicidal thoughts. When that woman reported those thoughts, Tufts did not recommend in-person evaluation or hospitalization. She recommended continuing the telehealth arrangement. Whether that constitutes negligence, whether it contributed to the outcome, whether a different doctor would have done differently, those are questions the jury will decide. And whether postpartum psychosis, a documented psychiatric condition, explains Lindsay's mental state on January 24, 2023, that is the central question of the trial. The defense's case begins next. They will call their own psychiatric experts. They will attempt to show that Lindsay met the criteria for an insanity defense, that she was not of sound mind when the deaths occurred. They will also attempt to call the TikToker who worked at McLean to contest the prosecution's description of the hospital and the care Linda received there. If that witness is allowed to testify, it will be the first time a social media creator has taken the stand in a high-profile criminal trial. How that testimony goes, whether it shifts the jury's perception, whether it introduces new information or confirms what's already been heard online, that's what's coming next week. Stay with us for that.